Yeah, I will be audible now. Yeah. I'm audible now. I have turned on the mic again. I should be audible now. Am I audible? Please let me know. Am I audible? I hope. Okay. Okay, they are now saying that I'm audible. Fine. I turned off the mic again and then turned it on again. So I think it should be fine now. Nandini, good evening. Meha says yes, sir. Guru says yes, sir. Taslima says yes. Aisha says yes. Akshaya, Nandini, okay. Kavinya, Deepika, okay. I'll repeat one more time in case you missed me out because of the voice issues. What you are seeing in front of your screen is right now the paper pattern of your law examination that will be there in the January attempt, okay, on 16th of January to be specific. So this will be your paper pattern. What I can see is you will be facing Indian Contract Act in 5 out of 6 questions. 5 out of 6 questions you will have Indian Contract Act. You can see it in question number 1, you can see it in question number 3, then question number 4, then question number 5, and then again in question number 6. So your Contract Act will be there in almost every question. Apart from question number 2, it will be there everywhere. Then if I talk about Companies Act, it will be there in question number 1, 2 and 3. 3 different questions from Companies Act. As far as SOGA is concerned, I can see it to be in question number 2, 5 and 6. Negotiable, question 4 and 6. Regulatory framework, only 1 question in question number 4. Then I would say LLP, only 1 question, which is question number 2. So this is basically the structure of your paper. You can take a screenshot, it is fine with me. You can copy it down, it is fine with me. Everything is fine. This will basically give you an idea that every chapter is important. You should not be thinking like this, that sir, I want to leave regulatory framework, I want to leave LLP. No, it is foolishness. There are very less number of pages which will help you fetch 6 to 10 marks. So if I talk about regulatory framework, it contains merely 7 pages. And the weightage you can see in front of your screen, it is worth 6 marks. So you just need to read 7 pages and you get 6 marks. If you compare it with Indian Contract Act, where you are supposed to read 150, 180 pages to secure your 30 marks. So LLP is a very smart thing to do. Regulatory framework is again a very smart chapter to be done. Then Companies Act again, partnership again. These are 4, I would say, and negotiable 5. These 5 chapters are something which you should not miss upon, because the number of pages are less, the number of hours required is less, and the marks are more. I agree, Contract Act requires a huge number of hours, devotion is concerned, and same with Sales of Goods Act, around 70 pages are there to secure your 20 marks. So smartly, first 5 chapters, which is regulatory framework, your companies, your partnership, your LLP and negotiable. These 5 chapters you should not be leaving at any cost, because the hard work is less and the reward is more. Then as far as Contract Act is concerned, I agree that yes sir, number of pages are more, I agree the concepts are difficult, I agree, but then you can see you will be facing Contract Act in every possible question that you have except question number 2. So you cannot leave Contract Act as well. And SOGA, to me, I'll make sure that I'll try to make it very easy for you so that you don't fear the chapter of SOGA. So we'll make sure that we are thorough with all the 7 chapters that we have in the curriculum. I hope we are clear with the paper pattern. You can just give me a thumbs up to let me know so that I can close the screen and start with the concepts. Are we clear with this much? Your paper pattern is there in front of your screen. Question number 1 is a compulsory question, and from the remaining 5, you need to attend any 4. Are we clear with this much? In case I get a thumbs up, we will move forward. Okay, I'll take partnership tomorrow, no issues. I might take it today as well, no issues. Are we clear with this much? Around 1720 that are there on YouTube. Are we clear? Those on Zoom can just reply me. Is this clear? Your paper pattern. You can take a screenshot, maybe copy it down by now. And I'm moving forward. Just waiting for your thumbs ups so that I can come to know that okay, we are thorough with this. Are we clear? Are we clear? Okay, I have a message from Meha Jain, a message from Aisha, Kavinya, Guru, Deepika, Preeti, Shivani, Thanuja. Okay, around 7-8 messages already with a thumbs up. Fine. So yesterday I remember we did around 4 questions, approximately 4 questions we did which were, like I said, very important for from your exam point of view. We'll try to cover around 4 to 5 questions today as well. All the important ones for your attempt. All the important ones for your attempt. And I will also tell you one more thing, sort of bonus for you. What I'm right now preparing is a book which is 50 pages only, 50 pages only, which covers almost 100 marks of your syllabus. Merely 50 pages which covers almost 100 marks of your law paper. All the important concepts, all the diagrams, all the charts, all the expected questions that are there for your general attempt. I will be launching this book next week and you will get this free of cost. You will get this free of cost. So 50 pages book, colorful book, which will cover almost your 100 marks of the law paper and will contain all the important questions and the expected questions for exams. So I hope you are very much happy with this news. I have been preparing this book since last 10 days. I need 3 to 4 more days. Almost 15 days I'll take to make this book for you. Only 50 pages, and 50 pages by that I mean basically sides. Okay, so just 50 sides and your whole law syllabus is done. So I hope you are very much excited with this particular book. You will get this at zero cost, free of cost. You will get the PDF for this. So I hope you are happy with this news. You should be getting this next week itself. Hope you will enjoy it. Hope you will enjoy it. Okay, starting now. From where we left yesterday, I have a message from Guru S. Meha Jain says, yes sir, just 50 pages, okay. And let me also tell you, on 12th, you have your accounts exam. On 12th, you have your accounts exam. On 13th and on 14th, 2 days basically, you will have lectures 8 a.m. to 8 p.m. live, free, on Zoom plus YouTube plus face to face obviously in Mumbai. So you can join in here also on 13th and 14th, which is a holiday. There will be lectures from 8 a.m. to 8 p.m. The whole of the syllabus will be revised along with question answers, along with writing practice. The session will be there on 13th and 14th. On 15th, it is basically your self-study. 15th is self-study. So hope you you will all join in here and we shall meet and cover the whole of the syllabus, 100% of it, along with writing practice. I will make sure you are able to write the questions. I will switch on the stopwatch so that we are able to finish the answer within the time prescribed. I hope we know this almost this much already, that sir, we have basically 100 marks to attempt, 100 marks which needs to be finished in 180 minutes. I hope we know this already. So basically for 1 mark you happen to get 1.8 minutes. So let's say if it is a 5 mark question, you basically get 9 minutes. So what I have planned is in this session, which will be there on 13th and 14th live, it will be at Andheri. It will be at Andheri. Face to face, YouTube live and Zoom. I will make sure that I put on the stopwatch and see to it that the question gets completed in 9 minutes if it is worth 5 marks. So we'll be revising as well. We will be doing the writing practice as well. I will be correcting your answers. I will come to your bench. I will correct your answer and will let you know that where exactly you need to improve. So in case it is possible for you, please join it offline if possible. And if you stay away from Mumbai, then obviously the YouTube and the Zoom option will always be there. So I'm just telling you, be ready on 13th and 14th of January, 8 a.m. to 8 p.m. Okay, 8 a.m. to 8 p.m. Okay, let's move forward. Let's come to the first question for the day. We started with Contract Act, I guess. We were on unit number 2. So we'll move forward to unit number 2 only and cover the next important question that we have in that unit. I'll open the page. Just give me a minute. Okay, here we are. Contract Act. Here we are, Contract Act. Sir, where I can get the Zoom link? You will be provided with everything. I will come up with a short video to announce this session, the batch, the timings and everything. You will get notification soon. You will get the links. You will get the soft copy. You will get everything. And you are attending, if you're attending offline, you will get the physical copy as well. So don't worry about that. It will be taken care of by me. Okay, don't worry. Okay, so I'm on Indian Contract Act. I'll try to do 4 to 5 important expected questions for your general attempt. All I want you is focus right now on the concepts that I'm trying to teach you, the important questions. Starting now. I basically want to reach towards unit number 2. Okay, here we are. Unit number 2. One important topic we did yesterday only, which is exceptions of doctrine of privity of contract. That was the last question that we did yesterday. We have one more question left from this unit number 2, which I want to basically do it with you. The first thing obviously would be the definition part. Which you ought to be knowing. And the second would be a short note worth 5 marks, 4 to 5 marks, which is this: consideration need not be adequate. Important. So I basically marked right now for the next 15 minutes, we'll be doing these 2 topics, which is definition of consideration. I'll make sure that you remember this by heart without mugging it, and conceptually we understand the same. Okay, so let's start. Let's not waste any further time. So we are on definition of consideration. Okay, I think we know this already. Question, the section 2 clause D that we have of consideration. Okay, I will be dividing the whole definition in 3 parts. Please look at me carefully. How do I do it exactly? The first half of the definition, next the second half of the definition, and finally the last half, which is the remaining part. That is it. So I have divided the whole definition of consideration in 3 parts so that we understand it conceptually and learn it forever. Starting with the first one: when at the desire of the promisor. Let me start with an example. Let's say we are planning to build a classroom. On the one side we have the class owner. On the other side we have an interior designer. Okay, on one side we have, listen carefully, on one side we have a class owner, on the other side we have an interior designer. Now the class owner is promising to pay rupees 10 lakhs to the interior designer to construct the whole class. So basically class owner is the promisor. He basically is promising to pay 10 lakh rupees to the interior designer for the class to be built. The specifications are like this. That's sir, there will be benches over here, there will be benches over here, there will be benches over here. Here we will have an entrance, a screen, a podium for the faculty, a projector, and 3 ACs. Okay, so this is basically the outlay, the structure that the class owner has told the interior designer to construct, and for this he is promising to pay 10 lakh rupees. So class owner is the promisor basically. So all the specifications has been said to the interior designer that sir, please construct this accordingly. The benches, 3 ACs, a projector, a screen, entry gate, and a podium for the faculty. Now the class owner promises to pay 10 lakh for this. After saying this to interior designer, the class owner basically goes away. After the class owner goes away, I basically come to look into the matter that what exactly is being constructed over here. So I, Vishwanath Sharma, myself, Vishwanath Sharma, I tell the interior designer that bro, you can just make a slight modification in the room. Can you please try and adjust to make a bathtub for me in between the class? I basically have breaks between the lectures, so I'm very much exhausted, very much tired. So what I'll do is I'll be in this bathtub, relax myself for 30 minutes or maybe 1 hour, and leave the room. Can you please do this much for me? Anyway, this the space is empty. The interior designer tells me that okay sir, I will make sure that the bathtub is there. I will cover it with the fence. I will cover it with a fence. Don't worry, and I'll construct the same for you. I was like very happy. Okay, thank you. Now after 7 days, the class owner, it comes to inspect the class if it is ready or not, and the class owner is seeing that the benches are there, the AC is there, the AC is there, the AC is there, the benches are there, the projector is there, the benches are here, the gate is here, the projector is here, the podium is here. Oh my god, what is this? Promisor is not sure, that the class owner is not sure that why exactly we have a bathtub in between the classroom. He asked the interior designer that why did you build this bathtub in between the class? The interior designer says, sir, one of your teammate from your classes came to me and told me to make the bathtub, and hence I made the bathtub. The class owner says, okay, fine, and starts to leave. The interior designer asks, sir, wait 1 minute. Where are my 10 lakh rupees? Where are my 10 lakh rupees? The class owner says, okay, the one Vishwanath Sharma who told you to construct the bathtub, please collect your 10 lakh from that person only, because I am not going to give you 10 lakh rupees now. Interior designer basically goes to the court. Interior designer basically goes to the court and sues the class owner. In the court, interior designer loses the case. Sir, why? The first half of the definition. When at the desire of the promisor, such a deep meaning this line, this phrase had. When at the desire of the promisor, the one who is going to pay you 10 lakh rupees, the work should be done according to his guidelines, according to his instructions. And if you don't follow the instructions of the class owner, he is not bound to pay you 10 lakh rupees because there is an absence of consideration. You will get 10 lakh rupees, but what is he getting? A classroom with a bathtub? It is of no use, sir. And hence, the class owner is not bound to pay 10 lakh rupees to the interior designer. Are we clear with this example? I basically tried to explain you this. When at the desire of the promisor, the one who has promised you to pay, the work has to be done according to his instruction, because he is the one who is going to pay you. Are we clear with this much? We have a case law for this. We have a case law for this. Many of you might have heard of it. I'm referring to basically the case law of Baldev. Here we are. Durga Prasad versus Baldev. I was referring to this. You can see the point as well. Here we are. The point. Consideration must move at the desire of the promisor. Are we clear with this? The first half of the definition. Are we clear? Are we clear? Durga Prasad versus Baldev. When at the desire of the promisor, the one who is going to pay you, you need to follow his instructions and his commands, because he is the one who is going to pay you and not someone else. Expecting it will be clear. So we had a case law over here. We had a case law for this much. Now we again have a case law for this. Many of you might have heard of this case law, Chinnaya versus Ramaya. Chinnaya versus Ramaya is what I'm referring to. The next case law, which is the promisee or any other person, considered to be one of the difficult case laws of the syllabus. I don't know why. To me, it is very easy. Let me give you the quick brief of the case law. So we basically have an old lady, basically mother. She has a daughter and she has a brother, basically maternal uncle for the daughter. Okay, I'll write it mama. Now, the old lady tells the daughter that I will give you all my property. I will hand over to you all my property in return of just one promise, which is you will pay a certain sum of money to your mama. It was exactly 653, something like that. You will pay this much amount to your maternal uncle every year. The mother is asking to the daughter, if you promise me this, I will hand over to you all my property that I have. I will name it for you. But just give me one promise that you will be paying this certain sum of amount to your mama every year. The daughter is very happy because she is getting a hell lot of property, and all she needs to do is just pay a small amount to the maternal uncle every year. So daughter agrees to it. Now, as soon as the daughter agrees to it, the property is now of the daughter. The daughter becomes the owner of all the property. Now, after some time, the lady dies. She is no more. She is dead. As soon as she is dead, the daughter stops to make the payment. As soon as the mother is dead, the daughter stops to make the payment. Now the maternal uncle is asking the daughter, okay, that why is it that you have stopped paying to me? The daughter replies, see uncle, you are getting consideration from me in the form of money, but I am not getting anything in return from you. Now, since there is no consideration, there is no contract. Since there is no consideration, there is no contract. And I am not bound to pay you anything because I am not getting anything in return from you. The uncle was shocked. He approached the court. Now the court said to the daughter that, see madam, the property that you received from your mother, is sufficient consideration for you to pay this amount to your uncle. I'll repeat, before you say me, I'll repeat. The court tells to the daughter that the property that you received from your mother is sufficient consideration for you to pay that sum of money to the mama, the maternal uncle. And hence, even though you are not receiving anything directly from the mama, you are still bound to pay the amount to the uncle. And basically, daughter lost the case and uncle won the case, and he was getting now all the money. That was basically means, in my whole example, I guess we understand that daughter was the promiser, because she promised to pay a certain sum of money. Mama was basically the promisee. So the lawmaker says it is not necessary that you happen to get something in return from the promisee. You may get it from any other person. So in my example, mother was any other person. What we received as a daughter from the mother was sufficient for me to pay the money to the mama. And here we are. The promisee or any other person. So basically, two different phrases, two half of lines, but both of them had a case law. Please tell me, are we clear with both the points? The yellow and the turquoise point. Are we clear? All I was wanting to do is make sure that you don't mug up things. You know it logically, so that in examination also, if a tricky question is asked, you are able to solve it. Are we clear with this much? When at the desire of the promiser, the promisee or any other person. Are we clear with this much? You can please tell me, are we clear with this much? You need to write this definition in the exam. Are we clear with this much? Because the rest of the definition is very easy. Okay, message from Meha Jain, message from Aisha, message from Shivani. Around 3-4 messages already. Okay, fine. I'm moving forward. The rest of the definition is very easy. It basically says this is past tense. Has done or abstained from doing is a past tense. Does or abstains from doing is present tense. Promises to do or to abstain from doing something is future tense. So easy it is. Message from Manisha. Okay. So easy it is. I'll give an example. The easiest example would be, sir, I happen to go downstairs. I pay the money to the vendor, and vendor hands me over vada pav. Sir, what is this? This is present consideration. Present. This is present consideration. That basically I am paying you with one hand and I am taking goods on the other hand. This is present consideration. Let me come towards future consideration. Basically, a teacher tells a student that next week they will start with the lectures of CA, and the student will also pay the amount to the teacher in the next week. So what we understand is, sir, it is an executory contract. It is an executory contract where consideration is going to be there in the future, and hence it is a future consideration. So very easy example for future consideration. Coming to the last one, coming towards the last one. So I explained you present, I explained you future. Coming to the last one, which is past consideration. Let's say I was finder of lost goods. I was the finder of lost goods. I found the true owner. I found the true owner and gave him his wallet. The true owner said to me, thank you, that's it. He did not give me anything. He just said to me, thank you, and that's it. I basically left. Now after 1 week, the true owner realizes that, oh my God, the purse had so many valuable things. It had my PAN card, it had my driving license, it had cash, it had my credit cards, it had my debit cards. It was so much valuable. And now the true owner tells me after 1 week, that he wants to give me a specific reward of rupees 1000. Now what you need to understand is, this 1000 is being paid for something which has been already done, and hence this is past consideration. So basically I have given you the example for all the three: past consideration, present consideration, and future consideration. Now we are still left with one more word, which is abstain. I want you to explain this also, abstain. Now what exactly we mean by the word abstain? It is a negative word, which basically means, with an example, sir, I basically happen to own a cake shop. I own a cake shop since many years, let's say since 2002, and my shop is running fantabulously fantastic. I'm earning huge money, I'm earning huge margins and profits, and doing very well. Now what I happen to see is, sir, there is a guy who is trying to open a cake shop just besides my shop. There is a guy who is trying to open a cake shop just besides to my shop. Now I am very much fearful. I basically am fearing that my customers will go away, my profits will come down, my sales will come down, and I will be getting hampered. So what I now do is, I happen to approach the owner and tell to him that, see, brother, see, I will pay you rupees 5 lakhs. All I am telling you is, don't open a cake shop around 1 kilometer away from my shop. I'll repeat. I am telling the new shop keeper that I will pay you rupees 5 lakh. Just do one thing. Don't open a cake shop near to my shop up to 1 kilometer. Do you agree or not? This is what I'm asking to the shopkeeper. He says to me, okay. So if we talk about the consideration part, obviously we all know this is a consideration for this guy. For me, the consideration is him not opening the shop. For me, the consideration is him not opening the shop. So this is basically called abstain. Which is something negative, not to do something. So consideration basically can be to do something or not to do something. It can be past, it can be present, it can be future. And this sums up the whole definition. This sums up the whole of the definition. Can you please tell me if we are clear or not? I tried to make sure that you are able to write this in the exam without mugging it up and write it conceptually in the exam, because this is very important. Are we clear with the definition part of consideration? Yes or no? Are we very much clear with the definition part? Yes or no? I will wait for your messages. Definition of consideration, section 2, clause D. When at the desire of the promisor, comma, the promisee or any other person, then the past tense, present tense and the future tense. Are we clear or not? I will move to the next question immediately. Are we clear or not? I have a message from Aisha who says yes sir. Okay, thank you. Message from Nandi, message from Meha Jain. Okay, around 3-4 messages I guess. Shivani, okay, thank you. Shivani says yes sir. Then we have general content says yes sir. Okay, thank you. Then we have again a very important question, a short note, a theory question, a short note, which is consideration need not be adequate. Consideration need not be adequate. This is a very important question for your attempt, and it's a theory question worth 4 to 5 marks. What I want to do is, I want to give you a real life example. I want to give you a real life example. Just give me a minute. Let me show you an example. Okay, here we are. See, this is a news. This is a news. You can see this in Times of India. You can see this in Times of India, which basically says Sonam Kapoor charged, a real news. Sonam Kapoor charged only ₹11. Sonam Kapoor charged only ₹11 to do this movie of Bhag Milkha Bhag. Okay, we saw the news basically. Only 11 rupees to do that movie Bhag Milkha Bhag here in front of you. Now, you need to understand why. If you are a layman, you will think that why even she took 11 rupees? She could have done it for free. Why even 11 rupees? As a layman, you would think this only. But what you should know is, sir, we are studying law, and especially we are studying Indian Contract Act, which basically says consideration is a must. If there is no consideration, there cannot be any contract. No consideration means no contract. So what we are trying to tell you is, sir, what is important is consideration. It is not important how much the consideration is. What is important is there has to be some consideration. How much is not important, but you must have something. So now let's take an example. If she didn't charge anything, let's say if there was 0 written over here, Sonam Kapoor charges 0 rupees for doing the movie Bhag Milkha Bhag. Let's suppose this was the news. In that case, in between the movie, if she happens to tell the producer that, bro, I'm not feeling good, I will not be coming to the sets from tomorrow. Producer cannot do anything. Producer cannot do anything because there was never a contract. No consideration, no contract. Means producer cannot even sue Sonam Kapoor. But sir, if we have a token of 11 rupees or even 1 rupee, now we have a proper contract. Now we have a proper contract. Now, if she now in between tells me, the producer, that I will not come from tomorrow, the producer can sue Sonam Kapoor. So basically the conclusion is, what is important is consideration. It is not important how much the consideration is. What is important is there has to be consideration. Are we clear? Are we clear? I gave you a real life example. Are we clear with this part? Consideration need not be adequate. I'll mark the important lines for you, but you can just tell me meanwhile if it is clear or not. I will meanwhile mark it for you, the important points that you need to write in the examinations. You can meanwhile tell me if it is clear or not. Okay, I'll keep marking. Okay, reading this much for you. Consideration need not be of any particular value. It need not be approximately of equal value with the promise for which it is exchanged, but it must be something. Something in return need not be equal to something given. Something in return need not be equal to something given. It can be considered as a bad bargain of the party. It can be considered as a bad bargain of the party. Let's move forward. Okay, the clarification. Agreement to which the consent of the promissory is freely given is not void merely because the concession is inadequate. If we have coercion under influence, then it's a different scenario. But otherwise, it is valid. And you have the example as well, which you can definitely quote in the exams. So I hope we are thorough with one more important question. It has been asked in the past. It can be asked again. It is very important. Consideration need not be adequate. Explain. 4 marks. So we basically have covered the important part, and we will move now forward. Okay. So expecting it will be clear from your side. In case you haven't liked the video, please do it now. In case you haven't liked the video, you can like it now. I can see only a few of the likes that are there. I'll meanwhile switch to the next question. You can like the video by now. This section 25 was there in the exam in the last attempt, so it will obviously not be there again. It has been there already. So we'll move forward. Not very important now for exams, and we'll jump towards undue influence, which is a very important topic. Undue influence. Okay, here we are. Section number 16, a very important topic. Undue influence. I'll give an example to make things very much clear for you. All you need to do is just see 3 things. I'll explain with the help of diagram. So we'll basically have 2 parties in near relationship. We will have 2 parties in near relationship. Next, the relationship will be in such a way that one party can dominate the will of the other. Next, in such a way so as to take undue advantage. Okay, so basically 3 things needs to be seen for section number 16, which is undue influence, which are, sir, there has to be basically 2 parties in near relationship. I will even give you example for the same. The relationship can be that of parent and child, teacher and student, doctor and patient, lawyer and the client, debtor and the creditor, master and servant, guru and devotee. 7 examples I gave you. So it can be basically any relationship, near relationship. The relationship should be such that one party is in a position to dominate the will matlab ichha, to dominate the will of the other. Like for example, a teacher can dominate the will of the student. In such a way so as to take undue advantage. Now let's say I happen to tell one of my students that please sell me your car for 50% less than the market value. I tell my student, please sell me the car for 50% less than the market value. And I'll make sure that I give you good marks. in the exams. Now this is, sir, definitely a case of undue influence. Because all the 3 things are there, which is, sir, 2 parties in near relationship. Then the second one, the relationship is such that one party can dominate the will of the other party in such a way so as to take undue advantage of the other. If that is the case, then the lawmaker says, okay, this is a voidable contract. Are we clear with this much? Are we clear with this much? I hope I'm very much clear with undue influence. I tried to make this very easy for you so that you remember this now forever. The diagram that I just made, I hope it is very much clear. Okay, I'm moving forward. Important topic. There can be a case study question on this. So if you know the concept, you can attempt it very easily. Moving forward, the upper half, which is law relating to minor. Law relating to minor. We basically had a question on this. in the past. If I'm not wrong, it was May 2022. I'll just give me a minute. It was a very good question. You just take me a minute. Okay, yes, it was November 22. I'll open the question for you. Here we are. Law Bank, past papers, November 22. It was question number 3B. It was question number 3B. Section 68, it was quasi contract. Here we are. 3B. The question. So whether it is a minor or in unsound mind, the provision is the same, because basically it is section number 68. So whether it is a minor or in unsound mind, the conclusion remains the same. So let's read the question and see if you can answer me. I've opened the question for the first time in front of you. A very important question. The provision is same for the minor as well as for unsound mind. Let's see if you can answer me or not. I'm very much sure you will give me wrong answers. Mr. Y, aged 21 years, lost his mental balance after the death of his parents in an accident. He was left with his grandmother, aged 85 years, incapable of walking and dependent upon him. Mr. M, their neighbor, out of pity, started supplying food and other necessaries to both of them. Mr. Y and his grandmother used to live in the house built by his parents. Mr. M also provided the grandmother some financial assistance for her emergency medical treatment. Okay. After supplying necessaries to Mr. Y for 4 years, Mr. M approached the former asking for him to pay back rupees 15 lakhs inclusive of 7 lakhs incurred for the medical treatment of the grandmother. Mr. Y pleaded that he has got his parents' jewelry to sell to a maximum of rupees 4 lakhs, which may be adjusted against the dues. Mr. M refused and threatened Mr. Y of legal suit to be brought against for recovering the money. Now we need to answer the following questions in case you read the question properly. The first one, will Mr. M succeed in filing the suit to recover the money? Second, what is the maximum amount of money that can be recovered? And third, shall the provisions of the above act also apply to the medical treatment given to the grandmother? So this is the question in front of you. You can read the first 3 lines if you want to. Mr. Y, aged 21 years, lost his mental balance after the death of his parents in an accident. He was left with his grandmother, aged 85 years, incapable of walking and dependent upon him. Mr. M, their neighbor, out of pity, started supplying food and other necessaries. And next question is in front of you. Can you answer me? There are 3 different questions. Answer me in brief. What would you might want to write in your answer? I will wait maybe for just 1 minute. The question is there in front of you. 3 different questions. You can answer them me in short what your answer is. I will read all the messages and then I'll come up with a solution. What is your answer? Can you answer me in brief? This has not been asked since 2 years now. So it becomes very important now. What would be your answer? Do we have an answer? Or else I will start to answer on my own. Let's see, this is what the provision is. Do you have any answer? There are 3 different questions that I can see. Do you have any answer? I'll wait 30 seconds. I will wait 30 seconds in case you have an answer. The first question says, will Mr. M succeed in filing the suit to recover the money? Obviously, the answer is yes. If you happen to supply any necessity to a minor or an unsound mind, you can recover the amount from the property. So the answer for the first one is yes, he will succeed. Yes, he will succeed. Okay, I have an answer from Aisha and Taslima. I hope I'm clear with my first answer. I'll come to the second question. What is the minimum amount of money that can be recovered by Mr. M? Now, everyone can see the 4 lakh is there, but there is one hidden adjustment which basically is the first line which says Mr. Y and his grandmother used to live in a house built by his parents. So don't you think apart from 4 lakhs, we also have an house with which we can repay the whole of the money. So it is not just 4 lakhs, it is basically the whole of 15 lakhs. So second question, basically everyone might have answered wrong. And that is why we are doing these questions. That is why we are doing these questions. That sir, the amount that has been expended can be recovered, obviously, not just from the jewelry, but also from the house that was given to the unsound mind. The last one, again a very difficult one, which says, shall the provisions of the above act also apply to the medical treatment given to the grandmother? Most of you will say no, but the answer is yes. The answer is yes, and that is what we are supposed to be learning. Sir, where is this written? Obviously, it is written in quasi contract unit number 6. It is there already, 68, the first box, but it is also over here. If you can just see the very first line, I'll open it for you. Point number 5. Point number 5. Here we are. I'll mark it for you. The case of necessaries supplied to a minor, it also covers unsound mind, or to any other person whom such minor is legally bound to support. I was referring to this line. I was referring to this line. So in my question, grandmother was someone who was dependent upon the unsound mind. So not just the money spent on that unsound guy, but also the money spent on the grandmother could be recovered, because the line says, or to any other person whom such minor is legally bound to support. So if the expenses are done basically for necessaries, then it can be recovered. So let's go in over there and see all the answers. So basically the first answer was yes. The first answer was yes. The second answer was the whole of 15 lakhs can be recovered. And the answer for the third one is again yes. Let's see the answers. Here we are. Here we are. Last line of point number 1. Hence, Mr. M will succeed in filing the suit to recover the money. Point number 2. The maximum amount of money that can be recovered by Mr. M is rupees 15 lakhs, the jewelry and the house. The third question. Hence, the above provision will also apply to the medical treatment given to the grandmother, as Y is legally bound to support the grandmother. One of the fantastic questions that we have was this. All 20-25 people right on YouTube and hundreds of them on Zoom. Are we clear with this much? Are we clear with this much? A very good question that I could come up with and help you decode the concept, worth 6 marks. It has been asked already in November 22. It has not been asked since 2 years. High chances, an important question for your attempt. Are we clear with this question? Are we clear with this question? I will wait for your messages. Are we clear with this question? Message from Meha Jain, okay. A message from Akshaya, okay. 2 of them. That's it on YouTube. Message from Aisha, okay. Around 3. Fine, fine, fine. So this was another topic that was going in my mind, which I wanted to, discuss with you, and I've discussed that already. So do remember this question. It is a very good one. Apart from this, there are other provisions for minor, which we'll discuss very quickly. The important ones, obviously. The first one, which says, a contract made with or by a minor is void ab initio. I'm basically starting to discuss along with you a very important topic, section number 56, which talks about this part as well. So I want your 5 minutes a complete focus on the chart that I'm drawing. Many of you might not be aware of this, so please focus. I'm giving the heading void. Now I'm dividing this into two parts. One is agreement, the other one is contract. So we have something called void agreement and we have something called void contract. Now when I say void agreement, I basically mean initial impossibility. When I say void contract, it basically means three words that we have in the textbook: subsequent, supervening, and the last one, post contractual. Okay. So when I say void agreement, it basically means initial impossibility. But when I say void contract, it basically means supervening, subsequent, or post contractual impossibility. Sir, we did not understand. This basically is void ab initio. That basically means 0 from the start. Over here, a valid contract at the start, but subsequently becomes 0 full stop. Concepts will now be, I would say, a bit more clearer. I wrote void ab initio, that basically means 0 from the very beginning. It was never enforceable. But as far as void contract is concerned, sir, it was valid initially, but afterwards something happened which made it impossible to continue with. So I basically mean the reasons are, it can be only two reasons. In the world, it can be only two reasons. Number one, change in circumstances, or change in law. A contract can become void only because of two things, which is either we have change in circumstances or we have change in law. Let me give you a very good example for void contract. Let's say BCCI and Nike, they were contracting with each other. Where BCCI was ready to supply a huge amount of money, rupees 10 lakhs, if Nike could supply 1,000 pairs of shoes specifically built for the Indian cricket team, men, women, and all the other players, state levels for them. The contract was made. The Nike guy said, okay, I'll do it. BCCI said, please make sure you hand it over to me in next 3 days. Nike said, okay, done. So basically the contract was made. Now, after the contract is made, this Nike guy goes to place the order in the factory of Nike. As soon as he reached the factory where the shoes will be manufactured, he sees that just now the fire has started and the whole factory is now burning. It is so obvious that now the shoes cannot be manufactured. what I understand is, sir, see, when the contract was made, everything was good. Everything was good in substance. Everything was good in substance. It was a valid contract. It was a valid contract. But sir, due to change in circumstances, this is change in circumstances. Due to change in circumstances, it is now no more possible for the Nike to hand over 1,000 pairs of shoes to the BCCI. So a valid contract becomes void because of change in circumstances. And hence my chart. Hence my chart. We did this one, which is change in circumstances, change in law. I'll give you the examples. Are we clear till now? Are we clear till now? Void agreement, void contract, initial impossibility, subsequent supervening or post-contractual impossibility, void ab initio, that basically means zero from the very beginning. And over there I've written a valid contract at the beginning, but subsequently because of change in law or change in circumstances, it is now no more enforceable. Are we clear with this chart? Are we clear with this chart? I have a message from Aisha. I have a message from Meha, Akshaya. Not sure about others. Are we clear? Are we clear? The difference between void agreement and void contract. It has been asked n number of times in the past. I will help you with the questions obviously now, right now itself. But before that, you should tell me if you are clear with this or not. I have a message from general content who says, yes, sir. Let's take an example. To conclude the topic, let's take an example. Agreement with minor. Agreement with minor would be the best example for void agreement. And this we basically took already. Fire in the factory. Fire in the factory. This we did already just now. I will open the questions immediately in front of you right now, the past questions, the important questions. But before that, please make sure you are clear with this. I'll meanwhile open the questions for you. Please make it fast. In case you have a doubt, you can ask me still. I will wait for 1 minute. I will wait for 1 minute. And I'll open the questions meanwhile for you people. June 2021, July 21. Okay. We can right now do question number 1A 3. Question 1A third part, which is X offers to sell his Maruti car to Y. Y believes that the X has only Wagoner car but agrees to buy it. Tell me, is this a void contract or a void agreement? I'm asking with respect to third case. I'm asking third case. X offers to sell his Maruti car to Y. Y believes that X has only Wagoner car but agrees to buy it. You need to answer me if it is a valid contract, void contract or void agreement. What is your answer? Please tell me fast. I'll search for the next question. Please tell me fast. I am waiting. I am waiting. Please tell me your answers. Sir, please still important questions in unit 2, sir. Yeah, first answer me this. First answer me this. I'm waiting for the answers. I have so many more questions to be discussed. Okay, Taslima says void. Okay. Void exactly what? Void contract or void agreement? Okay, Aisha says void contract. What about others? Akshay, I'm not asking void. I'm asking void contract or void agreement. Void contract or void agreement. General content says void contract. Taslima says void agreement. Meha Jain says void contract. Manisha says void agreement. That's it. Around 7-8 answers. Akshaya says void contract. Okay. Don't you think this is basically a bilateral mistake? Don't you think this is a bilateral mistake? Especially from the point of view of Y, who basically thinks that he has another type of car. The answer is there is an absence of consent. Basically, the meeting of minds is not there. Hence, it is void agreement. Here we are. The said agreement is void, not contract. The said agreement is void. The answer is there in front of you. The answer was given me rightly by Shriram. Manisha, Taslima gave me the right answers, whereas Aisha, general contents, Meha gave me a wrong answer. Akshaya gave me a wrong answer. I hope we are clear now. I'll give you one more question. I will give you one more question. Hopefully correct this time. Hopefully correct this time. Hopefully correct this time. Okay, answer to me. B. Answer to me the B part only. I'm asking only B part. Sohan agrees with Mohan to sell his black horse. Unknown to both the parties, the horse was dead at the time of agreement. Please answer me, is this void contract or void agreement? Just answer me this much. I'm asking you B. B for Bombay. Sohan agrees with Mohan to sell his black horse. Unknown to both the parties, the horse was dead at the time of agreement. Is this void contract or is this void agreement? I will wait for your answers. Please make it fast. I have so many questions to be discussed. I have so many questions to be discussed. Do we have an answer? Do we have an answer? Shriram, Akshaya, Manisha, Meha, Taslima, Aisha, general contents. Do we have an answer? I'll only wait 30 seconds. Else I move forward to the next question. Do we have an answer? Do we have an answer? Okay. Going forward with the answer. Going forward with the answer. Cannot see. I got 3-4 messages, I guess. The internet is a bit slow, I guess. I got message from Shriram who says void contract. I got message from Akshaya who says void agreement. General content says void agreement. Manisha says void contract. Taslima says void contract. Shiv Kumar says void contract. Let me come to the answer. Aisha says void contract. Okay, let me come to the answer. Don't you think the horse was, it is written, the horse was dead at the time of agreement. Don't you think this was initial impossibility? Just asking a question. Don't you think this was initial impossibility? Something which was not possible right from the very beginning. And if it was not possible right from the very beginning, don't you think this has to be void agreement? There are many people who have answered me void contract. Manisha, Taslima, Shiv Kumar, Meha and Aisha. Talking with you guys, you told me void contract. Don't you agree with me on this point? That sir, this was something which was impossible from the very beginning. The horse was dead at the time of agreement. So don't you think if this was initial impossibility, this has to be void agreement and not void contract? General contents gave me right answer. Akshaya gave me a right answer. 2 of them gave me the right answer. But others, I hope we are clear now. This is initial impossibility. See, I drew the chart for you only. It is still there in front of you. It is still there in front of you. I have written there initial impossibility. I have written 0 from the start. Don't you think over here in this possible example, the horse was already dead at the time of agreement and hence it has to be void agreement and not void contract? I hope we are clear. Aisha, Meha, Shiv Kumar, Taslima and Manisha. I'll see the answer and move forward. 3-1B. Here we are. Void agreement. Here we are, void agreement. Meha says, yes, sir. I hope we don't make the same mistake again. I hope we don't make the same mistake again. Here we are in front of you. The contract caused by mistake of fact are void. This is a mistake of fact as to existence of such matter. Something which means void from the beginning, and hence it is void agreement and not void contract. Okay, easy peasy, I would say. So we did 3 good questions based on this topic that we studied. So if you want, you can take the screenshot of this point if you want, and I will move forward. Okay, answers from Meha Jain, Manisha. Okay. Yes, sir. Okay. Moving forward. One more small point. This one. No ratification after attaining majority. I'll give you one more question right now. No ratification after attaining majority. See, an agreement with a minor is, we just discussed, void ab initio. An agreement with a minor is void ab initio. So now when the minor turns into major, you cannot ratify it. Sir, we do not even know what is the meaning of the word ratify. Okay, let's take an example then. Let's take an example. If you don't know what is ratification exactly, let me give you an example. A tells to B, please bring me a pizza. Please bring me a pizza. B in return goes to the shop and brings for A, instead of pizza, biryani. So I'll repeat my example. A tells to B, please bring me a pizza, I'll pay you. B goes to the shop and brings biryani. You need to understand, B has not done what he was told to do. B has not done what he was told to do. Now A basically gets 2 options. A basically gets 2 options. Number 1, to ratify or disown. To ratify or to disown. When I say ratify, I basically means approval, subsequent approval, and this one I guess we all understand, no. So I guess we understand now the word ratification. It basically means subsequent approval. So over here it says no ratification after attaining majority. Whatever you agreed with a minor is void ab initio, and a void agreement can never be ratified. What is 0 will remain 0. It will not become lawful. So agreement with a minor can never be ratified. A good point again, I would say, in this minor topic. Let's start easy peasy and not that important. Moving forward, under unit number 3, but I guess we did 3-4 important questions. Okay, fraud. Listen to my example very carefully. Let's say you happen to go to D-Mart. So why? To buy apples. To buy the apples. Now, there in front of you, you basically have an apple which basically has a sticker. On the sticker, the apple says that it is of export quality. The apple says export quality, 100% organic. So basically you happen to lift the apple, see the apple if it is okay or not. You see the sticker which says 100% export quality and 100% organic. Impressed by the sticker and inspecting the apple, you happen to buy the same. You happen to buy the apple. After reaching your house, what you discover is the apples are perished. They are infested. They are not worth consuming. Now when you looked on it closely, you found out that, sir, behind this sticker, behind this export quality sticker, there was basically a small hole which was making the apple as infested. So basically what DMart did was, it put on the sticker at exactly the same place where the apple was perished. Now you tell me if it is fraud or not. You tell me now if it is fraud or not a fraud. You might think of let the buyer be aware. You might think of let the buyer be aware. So just tell me, is this fraud or not a fraud? I will wait for your answers. If this is fraud or not a fraud, I will wait for your answers. I'm seeing your chats. Waiting, waiting and waiting. Waiting, waiting and waiting. Okay, Meha Jain says fraud. Meha Jain says fraud. Aisha says fraud. Okay. Taslima says fraud. General content says fraud. Okay, 4 answers who are telling me that this is a fraud. What about others? What about others? Are they zombies or what? What about others? Akshaya says fraud. Okay. So 5 answers saying fraud. That's it. That's it. Okay, let me come to the answer. Sir, everyone is correct. A very good answer, I would say, from general contents, Meha, Aisha, Taslima and Akshaya. The answer is, this is fraud, sir. Sir, why? This is something called active concealment. This is something called active concealment. Sir, it was hidden in such a way, that it could not be found from ordinary diligence. It was hidden such a way that it could not be found with ordinary diligence, and hence it was active concealment, and hence it was a fraud. So a very good example I felt like discussing with you, and hence I discussed it with you. Moving forward. Coming to the other important topic. Please mark, very important. When constitution is opposed to public policy, please mark it, very important. When is constitution opposed to public policy? Please mark it, very important. I am discussing all the difficult topics and all the important topics. Please mark this, very important. When constitution is opposed to public policy. Starting now. I think we know the first one already. So why? You have done this in Companies Act as well. If you could remember, in Companies Act we have a topic called lifting of corporate veil. Under that, the first case that we have is Daimler versus Continental Tire and Rubber Company, where we have studied this. That's a contract with enemy is void ab initio. A contract with enemy country is void ab initio. So I think we know this already. So moving forward to the next point, which is stifling prosecution. Moving forward, which is stifling prosecution. That is basically interfering with the court of justice. Let's say there was a thief who came to your house and took away all your valuables. There was a thief who came to your house and took away all the valuables. So you basically went to the police, filed an FIR and registered a complaint. Okay. Now after a few days, let's say the thief is caught. After a few days, the thief is caught. Now the thief is telling you that every valuable thing which he took from your place, he is ready to return it back. The thief is telling you that he is ready to hand it over everything back which he took from your house. In return, the thief is asking you that please take back the complaint that you filed against me. I don't want to go to the court. Please take back the complaint. I will hand you over back every valuable thing which I took from your house. The lawmaker says this is not allowed. This is not allowed. This is stifling prosecution, that you are taking money from someone in such a big event, and this is something against public policy, and this is something which is not allowed. So by taking money and settling the case, the lawmaker says it is not allowed, and that is what is stifling prosecution. Taking money to withdraw the case, not allowed. At least not when it is a big case like a murder, kidnapping, fraud. In that case, it is not allowed. That is stifling prosecution. Third one, which is maintenance and champati. Maintenance and champati, I don't know, it has not been asked in the exam since very, very long. A very good topic. Maintenance basically means you are dragging someone to the court just to annoy that person. So let's say you and me are enemy. I am taking you to the court, filing a case against you just to annoy you. Lawmaker says this is basically maintenance. To annoy a person, if you happen to file a case against him just to drain him mentally and physically, this is basically against public policy, and hence it is agreement. It is not even a contract, it is an agreement. That is maintenance agreement. It is unlawful. It is unlawful. Similarly, we have something called champati. Suppose you hire a lawyer to take a property on which you have illegal migrants. So you basically have a land in let's say village, and some of the people have captured that very land, and you basically hire a lawyer and ask the lawyer that please, if you can help me to clear up my land and get me the possession back. The lawyer replies, okay, I'll do it for you, but I have a condition. After winning the case, 50% of the land will become mine. 50% of the land will become mine. The lawmaker says this is champati. This is champati. Your intentions are malified. You want to take the advantage of the other person, and this is something exorbitant. This is something not acceptable, and this is champati here in front of you. Here in front of you. Maintenance and champati. I'll mark it for you. The word annoy, here we go. The word annoy. Then we have champati. Easy peasy, easy peasy, easy peasy. Okay, very easy and important. Fourth, I guess all of you know already. If you happen to basically tell someone that I will hand you over a job, a government job, if you happen to pay me money, this is not allowed. This is trafficking of public offices. This is not allowed. Same with public titles. It is not allowed. Easy point, I would say. Not discussing easy things, only discussing difficult things. Okay, mark it, very important. Section 27 and section 28. Please mark them, very, 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 very important. Section 27 and section number 28, I would say very important from your exam point of view. See, this was already asked in June 24. This we have done already. This we have done already. Section 56. This we have done already. 29 is very easy. 29 is very easy. 26 is very easy. These are difficult and important. Difficult and important. So please focus. I'll start with here only the word restraint, which basically means in simple language to stop someone. To stop someone. So restraint basically means to stop someone. Now we are talking about agreement in restraint of trade. I'll give an example. So we basically have Mr. X. He has an employee. He has an employee. Mr. X tells the employee that in case you happen to leave the job at my place, you cannot go outside and do the same job for next 10 years. So let's say Mr. X is a shop owner, let's say a goldsmith or something like that, and he has an employee working at his shop. Now Mr. X is telling the employee that if you leave this job and go away. You cannot do the same job for next 10 years. The lawmaker says this is invalid. This is invalid. This is outright agreement in restraint of trade. You cannot stop anybody from doing any lawful thing which he wants to do. You cannot restrict him. He can go and he can start the same business, the same job anywhere that he wants. So the lawmaker says, sir, if restraint of trade, see if it is reasonable or if it is unreasonable. In case it is reasonable, it is allowed and valid. In case it is unreasonable, it is not allowed and void. I will give you a real life example. I will give you my own example. My real sister got the job. I'm talking about 2012-13. My real sister got the job in Noida in a company called Ericsson. The company made my sister sign a bond which said if my sister would leave the job midway from Ericsson, she would be liable to pay 10 lakh rupees in compensation. Even you might have heard this thing, that if you join some place, they happen to make you sign a bond that if you leave the place midway before completing the tenure, you will be liable to pay XYZ amount. The reality is such bond is invalid. Such bond is invalid. It is merely an agreement in restraint of trade. It is invalid. The lawmaker is only saying that if the restraint is reasonable, then it is allowed. If it is unreasonable, it is not allowed. Next topic. Agreement in restraint of legal proceedings. Agreement in restraint of legal proceedings. So what does this mean? So basically A and B contract with each other. A and B contract with each other that A will sell to B apples and B will pay the money. Let's say apples 10 kg and rupees 3000, whatever. Now in this contract they have a clause. Which says A or B cannot approach the court in case of a breach. Lawmaker says this is not allowed. You cannot write this, cannot approach the court. This is outright restraint of legal proceedings. This is not allowed, sir. You cannot restrain anyone from going or approaching to the court. If this is a clause in the contract, then it is invalid. So basically two cases, two different topics I discussed with you. One of them was restraint of trade. And the other one was restraint of legal proceedings. Can you please tell me if we are clear with this or not? All those that are there, I'll wait for your messages. Let me know if you are clear with this. Agreement, important, very important. Agreement in restraint of trade and agreement in restraint of legal proceedings. Are we clear? Both of them quite important for your exam. Are we clear with these? Both the topics. Meha Jain says yes sir, okay. Taslima says yes, okay. Important questions of unit 4, sir. We'll come to unit number 4, don't worry. General content says yes sir, okay, thank you. Around 4-5 messages only. I'll wait for this. Maybe reply in a while or what. Next, So basically marked these two topics, and these were very important, Okay, moving forward. Nothing much left in unit number 3, to be honest. Unit number 4. I think we did this right in the last class. Can you please help me out? Did we do this topic in the last class? Can you please help me out? I think we did this in the last class. Is it? Joint promisors, a very important topic for your exams. Did we do this? Please help me out. I must have done around 8-9 cases with you. I think I did this. I did the same. Please let me know. I'll meanwhile go to the next topic. Any possibility of difference between questions, sir? Difference between generally they don't ask, but I'll give you a list of important difference betweens which you need to do. I'll give you a list of important difference betweens which you need to do once. Okay, I'll give you the list. Don't worry. So I think we basically did this already. Okay, moving forward. This is very important now. Moving forward. Then we come to the next question. Appropriation done already. Again, very important. Yeah, this part. I think we did this too. All right. Please confirm to me. I think we have done this already. Please confirm. Please confirm. Please confirm. Even appropriation of payments was done. Am I correct? Please help me out. Am I correct? Please help me out. So that I can move to the last important question of unit number 4. Okay, thank you. Okay, here we are. Important. Novation, recession and alteration. Important. Novation, recession and alteration. I'll help you out with an example. Please listen to me carefully. So basically we have, let's say, the classes, adnovate classes. Okay, let's say we have adnovate classes. It has contracted with, let's say, CAFC. It has contracted with CAFC. So what is the contract? The contract is quite simple. It basically says that KFC can open the outlet in the premises of the coaching classes, and it can sell the burgers to the students, and the contract was made. Okay. Now, one of the students went to the KFC, ordered a burger, ate the burger and fell ill. He basically got food poisoning. So Adnovate had a contract with KFC that KFC can open an outlet in the premises of Adnovate and can sell the burgers. But when one of the students went to the outlet and ate the burger, he basically got food poisoning, admitted to the hospital. Adnovate got so angry that it told KFC that, look, we are cancelling the contract with you, and now we will hire McDonald's. In place of you. So Adnovate basically what it does is it cancels the contract with KFC and enters into a new contract with McDonald's. So basically in English we happen to say this as substitution. Happen to say this as substitution, or I would rather say this as, in more easier language, old contract is gone and new contract has come in. In law, we happen to say this as novation. Section number 62. Please tell me if you are clear with this. I am trying to make the language very easy for you. I am trying to take very easy examples which you can connect with. Are we clear? With this topic of novation? Are we clear? Trying to make this as simple as possible for you people. Are we clear? Are we clear with novation section number 62? I'll quickly move forward to the next topic. If we are clear with this, Meha Jain says yes sir. Okay. We have Manisha, general contents, Akshaya, Taslima, Shiv Kumar, Manisha. Okay. The next one. Let's say a similar example. Innovate contracted with CAFC. Okay, I'm going with a similar example. One of the students went to the shop and ate a burger. Now previously what happened was the student ate the burger and got food poisoning and was hospitalized. What is now happening in this example is the student died. The student died of food poisoning. Now it is such a big news that what Innovate decided was, let's cancel the contract with KFC and let us not hire anyone else also. So we're basically cancelling the contract with KFC and not hiring anyone else as a replacement. So basically what we are doing is, old contract is gone and no new contract comes in. So simple. In law, we happen to say this as recession. Here we are in front of you. Recession. So difference you can see, say innovation, the old contract was gone and the new contract was entered into. The old contract was gone and the new contract was entered into. While in case of recession, only the old contract has gone and no new contract has came in as replacement. This is recession. I hope we are clear. The next one. When you happen to make small changes, and parties to a contract do not change, in that case we happen to say this as alteration. So I said it's now simple that sir, we are making changes in the contract and these changes are not big changes, these are small changes, and these small changes have been referred to as alteration in the Contract Act. The last one finally, which is, I'll take a real life example. Okay, I'll try and take a real life example. Vijay Mallya basically went to the bank and asked for a loan from consortium of banks, Bank 1, Bank 2 and Bank 3. From the three banks combined, he basically took a loan of rupees, these are real figures, 9,000 crores. So Vijay Mallya is taking loan from three different banks worth 9,000 crores to start with his airline business, Now for some reasons, the airlines did not work and it had to be shut down. Meanwhile, this was the principal, the interest that had accrued was 3,000 crores. This was interest, principal, interest. So now the total due is 12,000 crores. Now, Vijay Mallya is asking the banks that can you please forego, can you please let go, can you please relinquish, can you please compromise 3,000 crores for me. I can pay you out right now 9,000 crores in full and final settlement. Just let go of this 3,000 crore rupees. All the banks denied. They were like, no, you have enough and sufficient property to pay off the whole of 12,000 crores. Then why would we let go 3,000 crores? No, we will not let go. And ultimately what happened was Vijay Mallya ran away. Vijay Mallya ran away. Conclusion is, sir, had the bank let go this amount, had the banks let go this amount, I would rather say relinquish this amount, then it would have been remission. Then it would have been remission, section number 63. Then it would have been remission, that is section number 63. To let go, to forego, हिंदी में बोलते हैं माफ कर देना, part of the loan. This is remission, section number 63. So basically 4 important points as far as discharge of contract is concerned with mutual agreement. We have these 4 points, which are novation, rescission, alteration and remission. Please tell me, are we clear with this or not? Please tell me, are we clear with this or not? Novation, very important, okay? Novation, rescission, novation, rescission, alteration and remission. Are we clear or not? Section number 62 and section number 63, super duper important. Are we clear or not? I will wait for your answers. I will wait for your answers. General content says yes sir. Meha Jain says yes sir. That's it. That's it. I'll wait 30 seconds more in case we have any further messages. That's it. Moving forward, I guess. Moving forward, I guess. Okay, next one. So here we go. I did discuss with you these topics. The important ones, which is novation, section 62, very important. So can you please explain alteration? Alteration basically means small changes. The parties to a contract do not change. The parties to a contract remain the same. There is no change in the contracting parties, and the changes that have been made are small changes. That is alteration. I hope we are clear, Taslima. I hope we are clear. So novation, then we had this rescission, alteration, and lastly we will have this remission. So easy. Taslima, I hope we are clear. Taslima, I hope we are clear. Please tell me. Manisha says yes sir. Waiting. One important topic, unit number 5, and we end the lecture. One last important point from unit number 5, and we end the lecture, which is important question, has been asked in the exam twice, which is what do you mean by anticipatory breach of contract, and what are the effects of anticipatory breach of contract? I'll repeat my question, very important. One more time. What is anticipatory breach of contract, and what are the effects of consequences of anticipatory breach of contract? So I'll give you an example to make you understand this. First one, let's say the due date of performance of the contract is 25th of December. Let's say we are organizing a party and we have called upon Shah Rukh Khan to perform at the event. Okay, so let's say we have threw a Christmas party, and we have called upon Shah Rukh Khan to perform at the event. The contract is finalized, he is ready to come, he has asked for 3 crore rupees and everything is finalized. Now suddenly I come to know that Shah Rukh Khan is not going to show up on 25th of December. Suddenly, I come to know that Shah Rukh Khan is not going to show up on 25th of December. Maybe he has told me expressly, or maybe I heard it from somewhere that he might not show up. This is anticipatory breach of contract. You are anticipating that on the due date, the contract will not be performed. Now, I as an organizer have two options. I as an organizer have two options. Option number one, sir, I can straight away right now on 16th of December sue Shah Rukh Khan today itself, because I have hints, I have the idea that he might not perform his contract on 25th of December. So I can either sue him right now instantly, or maybe I can wait till 25th of December, wait for the actual date of performance, and then sue Shah Rukh Khan for non-performance. So basically two options I have: sue right now on 16th, or maybe sue on the 25th. Lawmaker says that if you sue right now on 16th, it is a better situation, a better option, rather than suing on 25th of December. Sir, why? What is the problem if I happen to sue it, Shah Rukh Khan, on 25th of December? Lawmaker says, what if there is some super winning impossibility between 16th of December and 25th of December? What if we have an earthquake? What if Shah Rukh Khan falls ill? What if Shah Rukh Khan gets injured? What if the function gets called off? In that scenario, Shah Rukh Khan will take advantage of super winning impossibility, and he might not be sued because we have super winning impossibility. So lawmaker says what you can do is sue him on 16th of December itself, rather than waiting till 25th of December, because in that case he might take advantage of some super winning impossibility, and that is what is effect of anticipatory breach of contract. Here we go. To either treat the contract as rescinded and sue the other party for damages from breach of contract immediately without waiting until the due date of performance. So this was the first option that you had. The second option says or he may elect not to rescind but to treat the contract as still operative and wait for the time of performance, and then hold the other party responsible for the consequences of non-performance. But in this case, he will keep the contract alive for the benefit of both the parties. And the guilty party, if he so decides on reconstruction, may still perform his part of the contract and can also claim advantage of super winning impossibility, which may have the effect of discharging the contract. Super important. Super important. One last time today I'm asking, are we clear or not? One last time I'm asking for the day, are we clear or not? Are we clear with what do we mean by anticipatory breach of contract, and what are the effects of anticipatory breach of contract? Are we clear or not? Asking one last time. I can also see that you have not liked the videos yet. Not very sure why. You can like it, the video, in case you learned something from me. You can obviously like the video and also tell me if we are clear with this or not. If we are clear with this or not. Meha Jain says yes sir. Okay. Meha Jain says yes sir. That's it. General content says yes sir. 64 is okay, you can read it once, not very important. Okay, general contents not very important. 62 and 63 were very important. Okay, so message from Meha Jain, message from general contents, that is it. Okay, there is zombies, not sure what you're doing. In any case, you can obviously like the video in case you learned something new, and I don't think it will make any sense for me to start with unit number 6 today. It will not make any sense to me starting with unit number 6 today. So what we might do is we end the lecture over here. Message from Aisha, message from Manisha. Okay, you can like the video if in case you haven't liked it yet. Kiran says second part of the effect. Can you please repeat? What I'm asking, what I'm telling you is, you can either sue Shah Rukh Khan right now today, or you may wait till the 25th of December. Let's say you're waiting from 16th December to 25th of December. You're waiting, not doing anything. Now, in between, let's say we have an unexpected event, a change in circumstances. Let's say we have a lockdown. In that case, Shah Rukh Khan will take advantage of the supervening impossibility that I was ready to come, but since lockdown is there, I cannot come. I'm so sorry. This is the advantage that he can take if you wait for the due date of performance. If I rather happen to sue him right now, I am in a better position. Kiran, I hope we are clear. Kiran, I hope we are clear and you understood what I'm telling you. I hope we are clear. Kiran, Dev Kota, I'll wait for your reply. I will wait for your reply. I hope we are clear. Is it? Okay, in any case, we are ending right now here itself. We shall meet tomorrow, complete with unit number 6, 7, 8, 9. A very important unit. All of them, 7, 8, 9 are especially very important. So in tomorrow's session, we shall be completing unit number 7, 8, 9. So you may leave right now and shall meet me again tomorrow at the same time, that is 7:30 to 9:30. And thank you so much. Good night, everyone. Can like the video if you haven't still, and we shall meet tomorrow. Kiran says, okay, sir. Okay. Chalo, bye, 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 bye. We shall meet tomorrow. Same time, 7:30 to 9:30. We shall end here. Thank you so much and bye. Thank you so much and bye. I hope you understood everything that we discussed in the session today. I hope you understood everything that we discussed in the session today. Expecting the same. Yeah, Janaganes, thank you. Bye. Hope to see you tomorrow again. Same time, 7:30 to 9:30. Yeah, Kiran, thank you so much. Manisha, thank you. Yeah, Meha, thank you. Yeah, good night, good night. एक बार